I understand that you've recently been appointed by the court to serve as a conservator for an individual with a disability. First of all, thank you so much for being willing to help someone who really needs you. Now, in the state of Tennessee, every conservatorship is individually tailored to meet the needs of the person with the disability, who's called the respondent. What this means is that your responsibilities as a conservator can vary from case to case. It is important to note that a conservatorship is not a total takeover of the person with the disability, but rather a conservator serves as an agent. The conservator is simply there to help the person with the disability make decisions he or she can no longer make for themselves, as determined by the court order. Tennessee is a best interest standard state, meaning it is your job to determine what is best for the respondent considering the circumstance. Because Tennessee does not define best interest or have a set of standards for conservators, we encourage you to first consult your lawyer about your specific fiduciary duties and to use the educational information provided by our office and other national standards. A good guide to use to carry out your fiduciary duties are the National Guardianship Association Standards of Practice. The National Guardianship Association provides the standards for consideration and implementation by all states to guide best practices. While resources may at times be limited, these standards can reflect both pragmatic and aspirational principles of practice. In many cases, best practice may go beyond what the state law requires of a conservator. To ensure consistency in the way the standards are applied, the following constructions are used within the document. Shall imposes a duty. May creates discretionary authority or grants permission or a power. Must creates or recognizes a condition precedent. Is entitled to creates or recognizes a right, and may not imposes a prohibition and is synonymous with shall not. The guidelines that appear in some standards are suggested ways of carrying out those standards. You can find the NGA standards on the OCM website or the NGA website. Feel free to follow along as I proceed through the video. There are 25 standards, and I will briefly review several of them. Keep in mind, these standards are a guide to assist you with your fiduciary responsibilities. It is your duty to make the decision that best applies to the situation for your respondent. It is also your duty to educate yourself on your court-ordered fiduciary responsibilities. Standard 1. Applicable law and general standards. This standard focuses on what you should know regarding your appointment order and your respondent. You must perform duties and discharge obligations in accordance with current state and federal law governing conservatorships. You must comply with the requirements of the court that made the appointment. You must exercise only those powers granted by the laws of the state and the powers granted by the order appointing you conservator. You must obtain and maintain an understanding of what is required and expected of you by local and statutory court rule requirements and necessary filings and reports. You must be educated about the nature of the person's disability, functional abilities, mental and physical condition. You must give full cooperation and assistance to any lawful requests for information. You must promptly report to the proper authorities abuse, exploitation, and/or neglect as defined by state statutes. In Tennessee, everyone is a mandatory reporter. Standard 2, the conservator's relationship to the court. This standard focuses on your interactions with the court. All decisions and actions shall be consistent with that court order and state law. Remember to obtain court authorizations for actions that are subject to court approval. If you need clarity or your authority is unclear, petition the court for instruction. All payments to the conservator from the person's assets shall follow applicable federal or state requirements, rules, and statutes, and are subject to review by the court. Submit reports regarding the status of the conservatorship to the court as ordered by the court or required by state statute, but no less often than annually. Check with the probate court clerk's office if you have filing questions. Your status report in Tennessee is due annually. Standard 3, the conservator's professional relationship with the person. Check out the Office of Conservatorship Management's video Respondent's Rights as an additional guide for this standard. Under this standard, be intentional to treat the person with dignity. Avoid personal relationships with the person's family, or the person's friends, unless you are a family member, or unless such a relationship existed before your appointment. Do not engage in sexual relations with the person unless you are the person's spouse or was in a physical relationship with the person before the appointment. Seek ongoing education regarding your relationship with the respondent. Standard 4, the conservator's relationship with the person's family and friends. Promote social interactions and meaningful relationships consistent with the person's goals, needs, and preferences. When it becomes necessary to dispose of the person's assets, with court approval, the conservator may give family and friends the opportunity to obtain those assets, particularly those with sentimental value. Make reasonable efforts to preserve property designated in the person's will and other estate planning devices. Maintain communication with the person's family and friends. Be sure that the communication with the person's family and friends would not result in substantial harm to the person. Make reasonable efforts to resolve any conflict. You are permitted to use conflict resolving tools, including, for example, mediation or elder care coordination, provided that the person with the conservatorship is willing and able to participate, and doing so will not adversely affect the person. The conservator of the property may pay reasonable fees and costs under this standard, provided there are sufficient resources. Standard 5, the conservator's relationship with other professionals and providers of service to the person. Treat all professionals and service providers with courtesy and respect. Strive to enhance cooperation for the benefit of the person. Cooperate with other surrogate decision makers for the benefit of the person. Develop and maintain a working knowledge of the services, providers, and facilities available in the community. Engage the services of professionals, for example, attorneys, accountants, physicians, real estate agents, stockbrokers, and other as necessary to appropriately meet the person's goals, needs, and preferences. Remember, you can delegate a specific power to an agent, which a conservator of comparable skills would delegate under the circumstances. Standard 6, informed consent. Decisions you make on behalf of the person shall be based on the principle of informed consent. Informed consent is an individual's agreement to a particular course of action based on a full disclosure of facts needed to make the decision intelligently. You stand in the place of the person and are entitled to the same information and freedom of choices as the person would have received if the person did not have a conservatorship. The following guidelines apply to the process for a conservator to provide informed consent for another. Encourage and support the person in understanding the facts and directing the decision. Maximize the person's participation in decision-making. Have a clear understanding of the issue for which informed consent is sought. Have a clear understanding of the options, expected outcomes, risks, and benefits of each alternative. Determine the conditions that indicate treatment or action. Determine whether the person has previously stated preferences regarding a decision of this nature. Determine why this decision needs to be made now rather than later. Determine what will happen if a decision is made to take no action. Determine what is the least restrictive alternative for the situation. Obtain a second medical or professional opinion when necessary. Obtain information or input from family, friends, and from other professionals. Obtain written documentation of all reports relevant to each decision being made. Standard 7. Standards for decision-making. Identify and advocate for the person's goals, needs, and preferences. Goals are what are important to the person. Preferences are specific expressions of choice. In Tennessee, you are required to use a best interest standard for the person. The best interest principle requires the conservator to consider the least intrusive, most normalizing, and least restrictive course of action possible to provide the person's need. The best interest principle requires the conservator to consider information received from professionals and persons who demonstrate sufficient interest in the welfare of the adult. Other information the conservator believes the adult would have considered if the adult were able to act. Other factors a reasonable person in the circumstances of the adult would consider, including consequences for others. Standard 8. Least restrictive alternative. In Tennessee, the court has an affirmative duty to ascertain and impose the least restrictive alternatives upon the person with the disability that are consistent with adequate protections of the person. And so do you. This standard helps guide you to utilize least restrictive alternatives. Carefully evaluate the alternatives that are available and choose the one that best meets the person's personal and financial goals, needs, and preferences while placing the least restrictions on the person's freedom, rights, and ability to control their setting. Weigh the risks and benefits of the decision and develop a balance between maximizing the person's independence and self-determination and maintaining the person's dignity, protection, and safety. When determining the least restrictive alternative, become familiar with the available options, whether it be for education, medical treatment, personal care, residence, vocational training, or otherwise. Strive to know the person's goals, needs, and preferences. Consider assessment of the person's needs as determined by specialists. Make individualized decisions. Notify or petition the court to restore the person's rights or limit your authority if an assessment so indicates. Standard 9. Self-determination. Provide the person every opportunity to exercise the rights the person is capable of exercising. Maximize the person's self-reliance and independence. Make and implement a plan that seeks to fulfill the person's goals, needs, and preferences. Standard 10. The conservator's duties regarding the person's diversity and personal preferences. Take time to determine the person's particular cultural, ethnic, and religious customs, practices, and values. Also, consider the person's views regarding illness, pain and suffering, death and dying, quality of life, relationships and societal roles, burial and funeral customs. It is also important to acknowledge the person's right to sexual expression. Standard 11. Confidentiality. Always keep the person's affairs confidential. Respect the person's privacy and dignity, especially when the disclosure of information is necessary. Limit disclosure of information to what is necessary and relevant to the issues being addressed. You may disclose or assist the person in communicating sensitive information to the person's family and friends, unless it will substantially harm the person. Alternately, you may refuse to disclose sensitive information about the person when disclosure would be detrimental to the person's well-being or would subject the person's estate to undue risk. Due to the fact that conservatorship of the person orders are narrowly tailored to the needs of the person, and standards 12 through 15 may not apply to all conservators, the next standard I will cover is standard 16. I encourage you to read through standards 12 through 15 for guidance on best practices with serving as conservator of the person. Standard 16. Conflict of interest. Ancillary and support services. Avoid all conflicts of interest and self-dealing or the appearance of a conflict of interest and self-dealing when addressing the person's goals, needs, and preferences. Conflict of interest arises where the conservator has some personal or professional interest that can be perceived as self-serving or adverse to the position or best interest of the person. This means that you must not take advantage of your position as a conservator by acting for your own personal or financial interests. Nevertheless, conservators are entitled to reasonable compensation with court approval. Become fully educated as to what constitutes a conflict of interest and self-dealing, and why conflicts should be avoided. Again, due to the fact that conservatorship of the property orders are narrowly tailored to the needs of the person, and standards 17 through 19 may not apply to all conservators, the next standard I will cover is standard 20. I encourage you to read through standards 17 through 19 for guidance on best practices with serving as conservator of the property. Standard 20. Conflicts of interest and self-interest. Avoid conflicts of interest or the appearance of conflicts of interest, and do not enter into transactions or take actions that will benefit yourself or any of your relatives. If a conflict or perceived conflict arises, disclose the conflict or perceived conflict to the court prior to any benefit being conferred and request permission to proceed. Refrain from personal or professional dealings that might put your own self-interest or that of another person above the interest of the person. Standard 21. Termination and limitation of conservatorship. Limited conservatorship of the person or estate is preferred over a plenary conservatorship, which is a full conservatorship where all rights are removed from the person. Seek termination or limitation of the conservatorship in the following circumstances: when the person has developed or regained capacity in areas in which the person was found incapacitated by the court, when less restrictive alternatives exist, and when the conservatorship no longer benefits the person. Do not interfere with the person's reasonable efforts to seek restoration or rights removed by the court, and support the person's efforts to seek such restoration. The person is entitled to advocacy to seek the restoration of the person's rights and to use the person's estate to pay reasonable costs for such advocacy. It is a good best practice to maintain documentation of the person's requests and the decisions. Standard 22, Conservatorship Service Fees. You are allowed to request reasonable compensation for your services. However, it is also your responsibility to conserve the person's estate when making decisions regarding providing conservatorship services and charging a fee for those services. All fees related to the duties of the conservatorship must be reviewed and approved by the court. Fees must be reasonable and be related only to conservatorship duties. You may have the option to seek payment of fees from the income of the person receiving Medicaid services only after the deduction of the personal needs allowance, spousal allowance, and healthcare insurance premiums. In Tennessee, the court will set the actual compensation to be paid, taking into account the complexity of the property of the person, the amount of time spent in performing fiduciary duties, time taken away from the fiduciary's normal occupation, whether the services provided are those the fiduciary should normally have provided had there been no need for a fiduciary, and such other matters as the court deems appropriate. Standard 23, Management of Multiple Conservatorship Cases. If you serve as a conservator for more than one person, limit the caseload to a size that allows you to accurately and adequately support and protect the person, including a minimum of one visit per month with each person and regular contact with all service providers. This information is being provided as a summary of the national standards as a best practice guide for you as a conservator. It is very important that you understand your fiduciary responsibilities and become familiar with the laws and court requirements within your court order. The full Standards of Practice document can be found on the OCM website at ocm.nashville.gov. Now, keep in mind that the information contained in this video is not legal advice and should not be relied upon as such. If you have any questions or are unsure about your responsibilities as a conservator, please speak with your attorney. Thank you so much for your service as a court-appointed conservator.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.